Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be a pleasure on our part to be able to listen to Professor Julian Arato, who has very kindly made the time to talk on the elastic corporate form in international law. Now, before we request Professor Arato to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Julian Raptor is a professor of law and co-director of the Dennis J. Block Center for the Study of International Business Law. His scholarly expertise spans the areas of public international law, international economic law, and private law. Professor Arato has published numerous articles on the law of treaties, international investment law and dispute resolution, international trade, contracts, and private law theory. His article on the private law critique of international investment law won the 2019 Francis T. Prize for Best Article by a Youngest Author, published in the American Journal of International Law. He also co-edits an open access casebook on international trade law. Professor Arato serves on the Executive Council of the American Society of International Law as co-chair of the American Society of International Economic Law Interest Group and as a member of the Institute of Transnational Arbitration Academic Council. Since 2018, Professor Raptor has served as an observer delegate on behalf of the American Society of International Law to the United Nations Commission on International Trade Law, Working Group 3. He is the editor of the International Decisions section of the American Journal of International Law. Before joining the Brooklyn Law School faculty, Professor Arato was an associate in law at Columbia Law School. He previously worked as an associate in the International Arbitration Group, where his practice focused on international investment disputes and international commercial arbitration. And before we listen to Professor Arato, we would like to request Professor Rizwanul Islam, Chair of the Department of Law, for his introductory remarks.
Thank you, Saki, for your introduction. Good afternoon, Professor Arato. Good morning, good afternoon, or good evening, dear listeners, depending on wherever you may be. I welcome you all to this webinar by Professor Arato. I have had the pleasure of reading his forthcoming article, which is going to be published in Virginia Journal of International Law. In his article, I think Professor Arato deals with a very pressing issue of contemporary international law. In theory, we all know that companies are the creatures of national law. Companies are not directly subjects of international law. Companies' status in international law may be governed by national law, but in reality, we also know, particularly those of us who has any interest in international investment law, we know that ISDS mechanism would invariably deal with various corporate protection issues. The FET treatment, fair and equitable treatment issue, or direct or indirect expropriation issues. In all these issues, the corporate form is a critical issue. If we talk about the Barcelona traction case decided by the International Court of Justice, things would look very simple. That if you are to be protected under international law, it has to be by the company. Or if we go by Barcelona traction case under customary international law, it has to be the state of incorporation of the company. But we have moved far away from that Barcelona principle. There have been a few thousand bilateral or multilateral investment treaties. And the problem or the challenge has been compounded by the presence of many ad hoc arbitral bodies, which has to deal with these investment disputes. In his compelling work, Professor Arato has very cogently shown that how the practice in the international arena, particularly the ISDS decisions, are having an impact on the corporate form. In one side, in some cases, the tribunals are giving too much emphasis on corporate separate personality. On some other cases, they are moving more towards the protection of shareholder interests. And I think Professor Arato rightly points out that this, in some way, is a sort of claimant bias, and perhaps naturally so, because these ISDS bodies are not justice delivering bodies only. They are also a kind of service oriented institution, and it has some ramifications for the ways it operates, the ways it decides its cases. And what do all these mean for corporate form and the various principles that the principal legal systems of the world follow in relation to corporate law? Overall, it's a very pleasant read, and dare I say, it is going to be a very, very well cited article. I'm taking that sort of uh, risk to say that it's going to be a very, very influential one. I thoroughly enjoyed reading his article, and I'm quite sure you would enjoy the talk. And I look forward to not only his talk, also to your questions. So thank you very much to all of you. Over to you, Professor Arato. Thank you once again.
Well, thank you very much for the much too kind introduction, Rizwan and Saquib. It's my absolute honor and pleasure to be here speaking to all of you about this topic. And so I'll just jump right in, and I'll be sure to leave a lot of time for questions and answers. And I'm really interested in having a dialogue with all of the listeners here. So thank you to all of you for coming and for attending this talk. So the title of the paper and my talk is The Elastic Corporate Form in International Law. And as previewed, I'm really especially focused on the interaction between the investment treaty regime and corporate law, or the corporate form. But just to situate this for a moment, all of this is part of a broader project of mine on the private law of investment treaties. I'm interested across my body of work in how investment treaties create private law for the world, how they create subtly, without really explicitly doing it, an international law of property, of contract, of corporate law, of intellectual property. And I'm interested in how the resolution of investment treaty disputes through investor-state dispute settlement, or ISDS, turns out to distort foundational concepts across each of these areas of private law, contract, property, IP, corporate law, with severe distributional consequences. So here in this paper, I focus on how investment treaties and ISDS are warping the basics of the corporate form in seemingly anomalous ways and with serious distributive consequences. So let me take a moment, knowing that we have a very mixed audience, let me take a moment to explain what investment treaties do, just with a really simple example. It's a complex regime, but I think it can be understood in a really simple way. And then I'll sort of follow this through in explaining my argument about the distortion of the corporate form in ISDS. So imagine you're a mining company, let's say a Canadian mining company, and you have a contract with a state, let's say New Zealand. A Canadian mining company, you have a contract with New Zealand to mine for gold. That's your business. At the request of the state, you structure your business through a local, wholly owned subsidiary. So you own a subsidiary in New Zealand, and that subsidiary has a contract with the government to exploit mineral resources, gold. It takes time to develop these resources. So you spend 5 years exploring the gold fields, figuring out exactly how much gold is there, and you sink a cost of about $500 million in doing so. Right when you're ready to exploit the gold, New Zealand announces that it is canceling your concession. Now you're out of business and you're over a barrel. So there could be good or bad reasons for the state to do this, right? Maybe New Zealand has a malign intent here. It wants to force you to renegotiate. It knows you've sunk a cost. You have over a barrel, so they want to demand a renegotiation at a better price. Maybe they want to get an investor who will do it for cheaper from some other country, right? Excuse me. Or maybe New Zealand has perfectly good reasons, right? Maybe New Zealand is concerned about environmental costs, labor issues, or health issues, and they want to regulate the mining industry more generally, right? So we can imagine good reasons or bad reasons for canceling your concession. But to the investor, of course, it doesn't matter, right? The investor is out millions of dollars and is watching billions of dollars in hoped for lost profits evaporate. So investment treaties give you, this investor, an international private right of action, nearly unique in international law outside of the human rights world. You can sue the state directly for money damages, including lost profits, in a highly enforceable international arbitration, ISDS. So zooming out, what investment treaties purport to do is reallocate three types of political risk, sometimes called country risk, the risk of investing in another country. They shift the risk of mistreatment to the state, right? They take away the risk of an investor that she will be treated in a way that would be deemed unfair. Right? They take away the risk that even if the standard of treatments are robust, that the investor won't get a fair shake in domestic court by giving the investor the opportunity to sue internationally, right? So they take away the risk of discrimination in domestic court. They take away the risk of delay in domestic court. And finally, they take away the risk that even if a state loses in arbitration, the state will simply not pay up. They do this by keying into vast multilateral agreements for the enforcement of arbitral awards, which are extremely efficient and effective. So they remove the risk of maltreatment, they remove or mitigate the risk of maltreatment, they mitigate the risk of an unfair shake in domestic courts, real or perceived as that risk may be, and they remove the risk that the state won't pay up. Why? Why do this? Why do states agree to offer these risk allocations to foreign investors? These treaties are bargains. They're bargains between states with the hope of credibly committing the state to protect foreign investors, not out of altruism, but in the hope of incentivizing efficient foreign direct investment. There is an assumption underlying all of this that FDI, foreign direct investment, is prosperity enhancing, that countries need it, and in order to get it, they need to credibly commit to foreigners by removing these certain risks. Now, we can challenge all of that. It's not entirely clear that FDI is prosperity enhancing. It's not entirely clear that investment treaties, in fact, enhance or promote FDI. There's empirical work that's very inconclusive on all of these questions. But what I just want you to understand for the moment is that at least what these treaties are supposed to do is a bargain. Protect investors in order to promote foreign direct investment. So what does this have to do with corporations? Well, you've already had a little bit of a preview of this, but on their face, investment treaties have nothing to do with corporate law. They're not international corporate law treaties. They say nothing about corporate law beyond the definitions of investor and investment. So here's all they really say. Most investment treaties just say the following. They say the definition of investor includes natural persons and legal persons, juridical persons, like corporations, LLCs, business associations, whatever. And they say if you're a natural or a legal person with the requisite nationality, then you count as an investor. What that means is in a bilateral investment treaty, an investor that is covered by the treaty is one from one state investing in the other. So these are always diagonal treaties, right? They protect investors from one state who invest in the other. The other thing these treaties say about corporate law issues is that the definition of investment tends to generally include, well, almost anything you can imagine, but this includes an enterprise. A local enterprise can be an investment, which means a corporation can be both an investor and an investment. And the definition of investment almost always also includes stocks and shares in an enterprise. And even what they call indirect equity in an enterprise, meaning kind of ownership interests or control interests in an enterprise that might be attenuated. You know, like there's a parent company owns an intermediary, which itself owns another subsidiary, which itself owns another subsidiary, which ultimately owns the local enterprise. The parent has an indirect ownership interest in the local enterprise. So all of those things count as investments. So investors can be companies or stockholders or shareholders in companies. Right? That's it. That's all these treaties say. They don't say what kinds of rights this shareholders or companies have with any kind of great specificity. They just say that's what an investor is. That's what an investment is. If you are an investor with a covered investment, you are entitled to fair and equitable treatment, guarantees against expropriation without compensation, other kinds of standards of treatment, and the procedural private right of action to invoke ISDS and compel the state into enforceable arbitration. Doesn't sound like it's much about corporate law. Turns out, most investors structure their investments through corporations, and it is mostly corporations and shareholders that bring suit, not just natural persons bringing suit for their own property interest in it. Like, you know, it's not usually a single individual who owns a hotel in a state that brings a suit. Those suits do happen, but usually the suits involve corporations in some form or another, either as the investor, as the investment. As a result, complex questions, core questions of corporate law come up regularly, although very often not explicitly, in international dispute resolution, in ISDS. What happens when these issues come up? If you really drill down into the cases and look at how the tribunals interact with basic questions of corporate law, the picture is very oddly ambivalent. What's odd about it is that, you know, in investment law, there's a very common critique that the cases are inconsistent, that they don't always come to the same result, and it's very unpredictable. Here, there is no consistency problem. There are a bunch of different case lines where issues of corporate law come down, and they tend to actually be resolved the same way over time. But if you hold the different case lines together, they're kind of incoherent. There's an ambivalence about formalism. In some instances, on some case lines, ISDS is highly, highly dismissive of formalities of the corporate form, waving aside, for example, the core feature of separate legal personality in allowing a wide range of shareholder suits that would never be allowed in domestic law. In other instances, ISDS is nearly reverential of the corporate form, for example, by insisting on a strict form of limited liability and hyperextending the presumption against veil piercing to the context of nationality shopping, arbitrage, regulatory arbitrage, veil piercing. Again, investment treaties don't provide for any of this with any clarity whatsoever. What I want to suggest is that one can account for this apparent ambivalence of form by shifting our focus, not from doctrinal analysis, but to thinking about who wins and who loses from the pattern of cases. Maybe this apparent doctrinal ambivalence or incoherence can start to seem a lot more coherent if we think about which interests are regularly served. And there is, it turns out, a consistent winner. But the answer might be surprising. It's probably unsurprising that it's not states that are winning out here, right? One might argue that, well, states are just getting the benefit of their bargain and international tribunals are faithfully executing the treaties as they're written. It's a simple doctrinal point. This is what the law says. Yes, maybe investment treaties deviate from domestic corporate law, but fine, in their infinite wisdom, states are capable of deviating, right? But it turns out that that argument doesn't hold water for reasons I'll explain in a bit, mostly because the treaties don't say any of this. Secondly, and maybe more surprisingly, it turns out that investors are not the big winner here. Right? There's a common critique in the field that there's a pro-investor bias in international dispute resolution. Well, if we take into account investors' interest as a class, which includes not only compensation for injury ex post after a dispute has arisen, but also, much more importantly, the transactional efficiency ex ante. Investors' interest in transactional efficiency in the making of investments. It turns out that many of these interpretations are actually quite, they go quite far towards undermining the investor's interests on the front end. In fact, many of these distortions harm investors' interests both ex ante and the interests of some investors ex post. So who are the real winners? It's really a narrow class of investors and a class that we know of as claimants, those investors who actually choose to bring claims ex post. Claimants are different from investors, even in an asymmetric system where only quote unquote investors can bring claims. Those who actually choose to bring claims and those who are actually capable of bringing claims is a much narrower set than the whole sum total of groups of people who are involved in the making of investments ex ante. And in fact, when the time to bring suit comes, there are plenty of investors who get left out in the cold. So the only interests being served are those, I would suggest, of claimants, where these tribunal interpretations are regularly reducing barriers to bringing claims, removing the risk in bringing claims, making more types of claims available. Once we sort of see it that way, it starts to become clear that the investment protection rationale of the regime is starting to subsume and overtake the purpose of the regime in promoting efficient investment. In other words, we might say that the interest of states in promoting efficient foreign direct investment is being sacrificed at the altar of the private right of action on the international stage. So in the time that I have left, I think I have about 15 minutes, if I understand that right, I'm going to briefly speak about the basics of the corporate form in national law and international law, and talk about how the political economy of the investment treaty regime puts pressure on this general consensus. Then I'll turn to how investor-state dispute settlement responds to these questions of form in what I talk about as an elastic formalism. And I'll discuss the pathologies in these responses from a corporate law perspective. And finally, I'll deepen the critique by shifting the focus to who wins and who loses, and make the case for my pro-claimant account. Okay, so the corporate form in national and international law. There's obviously a lot to say about the corporate form, and what I want to just focus on are two key principles at issue here. So everywhere in the world, whether they use the terms or not, the corporate form, wherever it's recognized at all, entails probably about 5 core principles, but again, I'm going to focus on the 2 most famous and most central, which are separate legal personality and limited liability. So let me say a few words about each one of them in order to set up the problems that are going to arise in the investor-state dispute settlement. So separate legal personality is, if anything, the core of the corporate form. It has been called the sine qua non of the corporate form. It's the only aspect of the corporate form that must be provided for by the state. You can't contract for separate legal personality. This is something that must come from general corporate law. It's famous, but it's not always well understood. In fact, if you drill into the doctrine, separate legal personality always entails 3 elements, which are themselves buttressed and set up by various kinds of legal doctrines. So separate personality, it's really like a constellation of doctrines and different points of law that come together to create this function. What are the 3 elements of separate legal personality? And they're going to be really important here for understanding how ISDS distorts separate legal personality eventually. So the first component is separate ownership, asset partition. And in law and economics, this is called the entity shielding. What it means is that the assets of the firm may own property in its own name, and the assets of the firm are unavailable for attachment by creditors of the shareholders. Right? Moreover, the assets of the firm cannot be withdrawn at will by the shareholders. If you want to get out of a company, stop participating in a company, you have to sell your shares. You can't withdraw the assets of the company. All priority for company assets, even when a company is unwound, go to creditors first, and then, and only then, to shareholders in various forms of distribution. The other elements of separate personality is that a company can contract in its own name and sue in its own name. So it's separate ownership, the right to contract in its own name, and the capacity to bring suit and litigate in its own name. This is usually controlled by centralized management, with very few exceptions, like the shareholder derivative suit. All of these are key to the efficiency of the firm as a vehicle for coordinating and organizing capital at scale. And it turns out ISDS tends to undermine each of these pillars. Without ever undermining separate legal personality by name, it tends to undercut the capacity of the corporation to shield and partition the assets of the firm from those of the shareholders. It tends to undermine the ability of the firm to exclusively sue in its own name. And as I won't talk about this here, but I'm happy to in the Q&A, it also undermines the capacity of the firm to contract in its own name. That's separate personality. What about limited liability? Limited liability, if anything, is probably the most famous feature of the corporate form, even to non-lawyers, right? That's what corporations are, limited liability, many would say. All this means really is that the creditors of the company cannot look through the company, cannot pierce the corporate veil to attach the assets of the shareholders. In other words, it's kind of the mirror image of separate personalities, entity shielding, right? Here we have owner shielding. shareholders cannot attach and creditors cannot attach the assets of the firm. And likewise, creditors of the firm cannot attach the assets of shareholders. Now, unlike separate legal personality, limited liability is not universal in time and space. There are plenty of regimes of corporate law historically that have had unlimited liability, which is more close to what we have in partnerships in at least American law today. But generally, advanced systems of corporate law have shifted to a limited liability regime on the assumption that this is efficient. Presumably, the theory goes that limited liability, a very strong veil of the corporation, allows shareholders to diversify risks by putting only some money into a company. And then if everything goes wrong, that's all they lose, right? You only in it as far as the amount that you invested. So that allows individuals to limit and diversify their risk, and it allows much more efficient allocation of resources. That's the theory. We could go far into this, but time is limited now. It turns out that limited liability is not as absolute as separate legal personality. So it tends to be super strong in cases of public companies, at least in America. It tends to be super strong in cases of contractual creditors or voluntary creditors. So if you're a creditor who has contracted with the firm, presumably you had the opportunity to protect yourself, knowing about the corporate veil. So the law is going to not really allow you to veil pierce very easily. But limited liability is weaker in cases of involuntary creditors, tort creditors. It's weaker in the cases of closely held corporations and parent subsidiary chains and so forth. Okay, so let me recap that. The two core features of the corporate form, separate legal personality is the absolute core, and it tends to be absolute, whereas limited liability is central in some form, but it tends to be more porous. National courts tend to be more willing to abandon formalism in the context of limited liability when the equities of a case require it. International law, public international law, tends to just adopt all of this, right, wholesale, on a general principles methodology. The famous case of Barcelona Traction, as Rizwanul already mentioned, simply lifts all of this stuff and copy pastes it into international law. What's odd is that of all places, it's the investment treaty regime which is explicitly concerned with promoting transactional efficiency, where we see these efficient or theoretically efficient structures of the corporate form start to crumble or start to be distorted or hyperextended in highly inefficient ways. And before I turn to exactly how that happens, I want to just suggest that something about the political economy of the investment treaty regime is putting intense pressure on the corporate form. Remember, treaties don't say anything about corporate law, but there are certain investment practices that make these issues come to the fore really regularly. I'll just mention three. The first is that it is a fact that most cross-border investment, or at least a great deal of cross-border investment, happens through locally incorporated entities. There are reasons why investors might like to invest through locally incorporated entities, but really regularly, host states demand that if you want to enter our country and you want to do business here, and you want to set up an investment, you have to do it through a local subsidiary. They do this in the hope of tax revenues. They do this in the hope of getting local labor involved. They do it in the hope of knowledge transfer. And there's lots of reasons why. But it's a simple fact that lots of investment happens through local subsidiaries. And the investment treaty regime does not normally allow local subsidiaries to sue, right? It's a diagonal regime. Remember, it's foreign investors from the home state get to sue the host state. So the reality of demanding local incorporation runs a risk of meaning that these investment treaties will not extend their protection to a large swath of investors. Right, so that puts pressure on the corporate form. The other thing is that investors and their counsel have long, deep experience with structuring investments through chains of parents and subsidiaries to take advantage of various kinds of international tax benefits, international tax treaties, to regulatory arbitrage and so forth. And they're no strangers to using this creative methodology to either get around obligations that they don't like or to take advantage of benefits from various types of domestic and international regulatory regimes. And here, as elsewhere, there is a practice of structuring investments through large chains of subsidiaries to take advantage of investment treaties that would not otherwise be available. to nationals of the home state. And lastly, there's a general belief among all participants in this regime at every level, from treaty making to adjudication, that what this regime is about is reducing risks for investors, not imposing new risks on investors. The goal is always to promote investment, which is thought to be prosperity enhancing. All of this comes together to prompt really aggressive claims by investors and investor counsel at the dispute resolution phase to ensure that the investors that they represent can access ISDS. And we can't blame them for this, right? Of course, if you're at a major law firm representing an investor, which is a locally incorporated entity, you're going to do everything you can to advise them to be able to acquire recompense at the adjudicative stage, right? That's natural. So we see constant claims that not only can the local entity bring suit, but also their shareholders can bring suit. And it's perfectly plausible to structure investments through chains of parents and subsidiaries and shop for nationality protection in order to make sure investment treaties are doing their work. All of this puts intense pressure on the corporate form, which normally wouldn't allow all of these kinds of things. And so ISDS tribunals are confronted with a stark reality that there's these sort of basic assumptions of corporate law, but if you held the line with all of them, arguably investment treaties' scope of protection would be narrow. Now, that's not necessarily a bad thing, but it is a pressure at the adjudicative stage. It's a pressure that constantly gets raised. So ISDS, in response, has tended to, I think, do the wrong thing every time and consistently. They've allowed shareholder claims not only for harms to shareholders' own rights that they would always be able to bring, like, for example, interference with governance rights, but they allow shareholders to do things no domestic law would ever let them do, like bring claims for what is known as shareholder reflective loss. What that means is a shareholder claim for the state's harm to the firm, which happens to diminish share value. The reason no domestic law allows this is because claims for reflective loss basically allow shareholders to make an end run around the corporate form, around entity shielding, and withdraw assets that rightly belong to the firm by suing the third party who owes money to the firm and collecting that money directly. This allows doing an end run around creditors who normally expect priority on those assets, and it allows doing an end run against other shareholders who would expect at least parity on those assets. Now, this might sound like it's no problem. If shareholders can run around protecting themselves, good, let them protect themselves, right? But often the amount of assets available to go around when a firm is out of business is much lesser than you would normally expect. And it could be the case, and frequently is the case, that all of the investors in the firm, creditors, shareholders of all kinds, are going to have to take a haircut, are going to have to get less money than they expected. And if that's the case, then if one shareholder gets in and takes their proportional amount out first, that means there's even less for everybody to go around. This creates really perverse first mover incentives, right? The end result is, in allowing these kinds of shareholder claims, all kinds of harms come up. The most obvious are harms associated with claim proliferation. It's not just the company that brings a suit against the state, but countless shareholders can bring suits. This creates opportunities for multiple bites at the apple. You lose one, you can bring a suit and win the next time. And we've seen cases where that has happened, right? So harrying the state in multiple instances. And it creates risks of double recovery, risks which are unavoidable. If the shareholder recovers first, then it is unavoidable that that shareholder will recover more if the firm subsequently wins its suit. Even if you reduce the firm's overall winnings pro rata, you cannot prevent the shareholder from enjoying whatever recovery goes to the firm because they haven't sold their shares, right? They still own shares in the firm. So that's all kind of, those are famous harms with the multiple claims problem, the shareholder reflective loss problem. But what's less understood, unless you adopt a corporate law perspective, is that all of this has massive ex ante consequences for investors and states, because creditors notice these things, and it boosts the price of credit, right? When creditors say, okay, I'm going to give credit to this project in this corporation, expecting priority if things go wrong in firm assets, only to find out that shareholders can avoid owing anything to creditors by running around and bringing suit directly themselves, the next time around, creditors are going to have to put a much higher risk premium on their offer of credit or make credit just simply less available, right? So all of this raises the cost of credit, which means the costs of doing business go up for all concerned, precisely the opposite of what investment treaties are supposed to do. What about limited liability? Well, here, all of a sudden, we see the corporate veil is supercharged in investment law. In cases where there's security for costs are an issue, for example, investment tribunals have said we would never pierce the corporate veil, right? Why, of course, this is such a central piece of the corporate form, right? With separate personality, they just ignore it and say, oh, look, investment treaties allow these kinds of suits, and here we are. Whereas with limited liability, suddenly, oh, no, we would never pierce the corporate veil under any circumstances. In the context of limited liability itself, like a security for costs situation, it's not beyond the pale to have strong limited liability protections, but tribunals also hyperextend this presumption of against veil piercing to contexts where it really doesn't make as much sense. For example, allowing nationality shopping by shell companies, where a company structures its investment through a third state that has investment treaty protection with the host state. It enables companies to get investment treaty protection that their original state of nationality would not enjoy. From the perspective of the host state, what that means is that as long as you have even one bilateral investment treaty with any country, you have to assume that any foreign investor is sophisticated enough to structure their investment through that country and therefore get bilateral investment treaty protection in investing in your country. In other words, you have to price in all of the risks associated with investment treaties and ISDS in your interactions with every single investor. Bilateral investment treaties become multilateralized in this way, as Stefan Schill has argued long ago. So this might be inefficient as well. It might be that some investors don't really need investment treaty protection, but now the state can't give them a better price because they just have to assume that that investor, after investing, can just change its nationality and take on investment treaty protection without even notifying the state. All of this is harmful from an efficiency perspective. All of this raises the cost of doing business for all concerned. So it doesn't benefit states clearly. It doesn't benefit investors, at least in their ex-ante life. So who are the winners? The reality is that the winners are that class of investors who choose to bring claims ex post. All of these cases are reducing the barriers to bringing claims and reducing the risks of investors in bringing claims, right? It doesn't actually benefit the making of investment. It doesn't benefit non-treaty covered investors, but it does expand opportunities to bring claims. And so, in other words, all of this is boosting the access to justice values of the regime, which are important enough, but remember, it's access to justice for a privileged class of capitalist investors. And the reason we afford them a privileged form of access to justice is not because we all think these are the people who require special treatment. Intrinsically, it's because we think this will incentivize investment. And if we're supercharging access to justice for this privileged class at the expense of promoting efficient investment, then we really need to think carefully about whether this regime is doing what it's supposed to be doing, or whether it's frankly worth having at all. All of this also points us to reform options. I do think that there's a role for international investment law, but when we think about how it ought to be reformed, we need to think really carefully about what values that we're promoting with various reform options. Are we simply promoting the value of dispute resolution and access to justice, or are we keeping in mind the priorities upon which this regime was sold in the first place, in enhancing the efficient promotion of investment across borders, which we still at this point believe to be prosperity enhancing? Right now, at least if we focus on how the regime interacts with corporate law, which is where we would expect efficiency to be most prioritized, it turns out that the regime is undermining transactional efficiency in the interest of expanding access to justice for the privileged few. And that, to my mind, is something that has to change. I look forward to your questions.
Thank you very, very much, Professor. We do have a lot of questions, and whenever you're ready, I will convey the questions to you. All right. Professor, here's question one. So, what is to be done in order to make the jurisprudence more consistent?
Yeah. This is very hard to answer. And it's hard to answer because it's actually easy to answer, but it's almost too seductive. The easy answer is too seductive, right? So there's a lot of problems in the field with inconsistent jurisprudence. Actually here, it's an incoherence problem, right? I mean, the case law on shareholder claims is quite consistent. The case law on limited liability issues and nationality shopping, it's all very consistent, oddly for the regime, but they don't make sense when you hold them against each other, right? It seems like, oh, the regime is totally formalist here, and here it's anti-formalist. And it only starts to make sense once we see that there's a consistent winner here, which is claimants. So that's a coherence problem, but in the interpretation of the standards of treatments, there's pretty wild inconsistency. And the easiest answer to how you would solve the consistency problem is to create a court, right? To get rid of this fragmented system of jurisprudence where you have one-off tribunals who are sort of relying on each other as precedents, and create a more streamlined multilateral court style body or an appellate mechanism, something modeled off of the WTO, for example, although that is obviously not going so well at the moment. So I think it's too simple of an answer, not because it wouldn't solve the consistency problem. I think it's too simple of an answer because the consistency problem is not the only problem, and solving that problem is not a panacea. It is also possible that a court could solve the consistency problem by reifying all of the worst interpretations of the regime, right? So we need to think not just about consistency, which is quite important, and I've written about it elsewhere. I really do think it's important, but we need to think about it as one problem to be solved among others, and probably it's not the most pressing problem. The more pressing problems are the damage that we are doing to our basic legal institutions through this seemingly narrow regime in this narrow corner of international law that tends to have enormous reach because of how enforceable these damages awards end up being.
Thank you very much, Professor. Professor, here's our second question. By protecting indirect equity, are the arbitrators applying investment treaties or are they manufacturing provisions?
So this one is actually, you can't pin it on the arbitrators. Investment treaties in the definition of investment literally always say an investment is an asset, they almost always say an asset of any kind, but they often list the types of assets that count. And in the part that has to do with corporate stuff, they'll usually say an enterprise, stocks and shares in an enterprise, or indirect equity into an enterprise. Now, they don't all say indirect equity, but many of them do. There are some treaties which don't say it, and tribunals pretty much always read indirect equity into those treaties. So in those cases, yes, tribunals are literally making it up. It's not entirely clear to me that they would have even noticed in all cases. So some of this depends on whether the litigants actually raise that issue, because there's such an assumption that these treaties look the same time and again, that sometimes you see that litigants don't actually notice the differences, which is not great, but happens. And so you don't necessarily put this at the feet of the tribunal in all cases. We really have to see what was raised before them or whether everyone was just making an assumption. But usually these treaties cover indirect equity. That is a very odd thing to put into a treaty, but I don't think that alone I would call lawmaking by tribunals. Where I think the lawmaking happens is the treaties clearly say they apply to stocks and shares and indirect equity, but they don't say that they apply in exactly the same way to every kind of investment. In particular, they don't say that they expand the nature of rights that you would hold as a shareholder into including rights to speak for the firm that you would never have had. So I can easily see why we would say that if someone expropriated my shares, like took the shares rather than the company, or if someone prevented me from voting my shares, if a state prevented me from voting my shares, that I would have a claim. That's what we call a shareholder direct claim for interference with my rights as a shareholder. Where tribunals, I think, cross the line is by assuming that since stocks and shares are covered investments, investors, owners of stocks and shares, can simply do all the same things that the company can sue and sue for harm to the company and directly recover, getting around the company. That, I think, is lawmaking. I have to admit that it's very ambiguous in the treaties. So it's not the kind of case where they're flouting what's in the treaties. It's just that the treaties don't give them any reason to deviate from the general consensus about what corporate law requires everywhere in the world, including public international law. And proper treaty interpretation requires looking to public international law. 31.3c of the Vienna Convention says you have to look at general rules of international law in interpreting a treaty. And here, if the text is ambiguous, I mean, everyone has read Barcelona Traction at this point. Yeah, so that's where I see the real problem.
Thank you very much, Professor. Here's your third question. Could an investment protection regime, like General Agreement on Trade and Tariff Gap, address the concerns raised in the talk?
I'm sorry, address the
concerns that were raised in your talk.
Let me see if I'm understanding this question right. Would a multilateral treaty modeled on something like the GATT in the trade context address some of the concerns? Yeah, so I do think a multilateral treaty could address some of the concerns in much the same way that a multilateral court could address some of the concerns. But again, the problems are the same. It's a question of what's in it, right? So the treaty shopping question goes away if you have a multilateral treaty. Everyone is subject to the same treaty, and so no one can complain that this wasn't an offer to arbitrate with everyone from all of these countries, right? So sure, the Energy Charter Treaty is a very multilateral treaty, and it's a particularly aggressive investment treaty, but it covers a lot of countries, and so you can't really complain if you get sued by investors from any of them. So it does remove that concern. But again, the question is, how is the treaty designed and what's in it? And the simple fact of multilateralness, whether it's at the treaty, on the treaty itself or at the adjudicative stage, it only resolves the consistency question at the end of the day, right? The predictability question. And these are really important, right? From a rule of law perspective, we say we're worried about consistency and predictability in domestic law, so we impose these international regimes on you to discipline states, the theory goes, the paternalistic theory goes, to discipline states into being more consistent and predictable. And then it turns out that the investment treaty regime has the exact same rule of law problems that we were concerned about at the domestic level. That's pretty embarrassing and problematic. And so yes, a multilateral convention solves that in the same way that a multilateral court solves that, imperfectly, but they both go towards solving that. But it doesn't do anything to solve these problems of formalism and the corporate law, of the problems that I talk about elsewhere in how investment treaties distort contract law. And that's because none of that's in the treaties to begin with. Tribunals are just maybe doing their best, right? I'm not trying to say that they're just, malignant actors who are doing something on purpose to destroy corporate law or contract law or property law. They're doing their best to apply treaties in front of them. That's my best guess. But you have to make some decisions when it relates to corporate law or to contract law or to property law. And if the treaties don't guide you and the litigants don't especially do a particularly good job, then bad law gets made. The odd thing is that litigants have gotten really sophisticated in making these kinds of arguments more recently, but tribunals have been really locked into the early awards and the early decisions that were made. So even though we don't have formal precedent, there's a stickiness to these really problematic early interpretations. And it turns out, I didn't mention this in the talk, but I do in the paper, states have actually been trying to address these areas in their treaties very explicitly in recent treaties. For example, treaties modeled off of the NAFTA try to remove the old NAFTA, try to remove the ability of shareholders to bring claims for third-party harm to the firm, shareholder reflective loss claims. They do this by instead proposing a derivative suit model where a controlling shareholder can cause the local company to bring suit with recovery going to the company and being distributed through normal channels. That would be fine, but tribunals tend to ignore that. And they allow shareholders to bring claims anyway. They say, sure, there's this derivative mechanism, but there's also the possibility to bring shareholder claims. Similarly, with treaty shopping, tribunals ignore denial of benefits provisions modeled off of tax treaties, where states have tried to create mechanisms that allow them to deny the treaty benefits to a mere shell company that has no business in the home state. And tribunals have found all kinds of creative ways to say, well, it doesn't really count or it doesn't really work. Which I'm happy to get into, but all of that just goes to say that the treaty making efforts don't seem to be doing the trick because of the stickiness of these old interpretations.
Thank you very much, Professor. Here's your fourth question. However improbable it may be, could the re-emergence of a Galgo doctrine-like insistence on settling in this investment disputes by national courts be an appropriate answer to the challenges of corporate elasticity?
Totally. So I don't know if I go all the way there myself in terms of my normative position. I still can see scope for a justified and justifiable regime of international treaty-based protection with international arbitration. for at least some things like expropriation protection. Maybe even on some models of fair and equitable treatment, I could sort of see it. So I'm not necessarily a Calvo proponent. So when I said absolutely to the question, what I meant to say is that if you go back to Calvo, you solve all of these problems, right? And I let's say both sides of Calvo, right? So the only treatment foreigners are entitled to is national treatment, non-discrimination, and all of these disputes are to be resolved in the local courts. If you do those two things, you're not going to have these problems, right? But then you don't have the regime anymore, right? So I'm sort of doing an imminent critique of the regime on the assumption that we've set up this regime to incentivize foreign direct investments. We've gone beyond Calvo, which is the sort of arguably the status quo position, at least of the states of the global South, when these treaties were starting to get negotiated. The bargain is to drop that and go for the sort of more, Western Hull style treaty protection model, in the hopes of generating foreign direct investment. And once we've done that, then we start to see all of these problems. So yes, you go to the Calvo route, you get rid of all of these problems, but you might throw the baby out with the bathwater if it turns out to be the case that investment treaties do promote FDI and FDI is prosperity enhancing. Again, those might not be true, in which case, what are we doing here? We should probably pack up these treaties and go home. But I'm not ready to say that that's the case yet. I haven't seen convincing evidence. There is empirical evidence that investment treaties don't promote FDI, but it kind of tends to be weak, right? The nature of that evidence tends to be interview based, where there's, corporate executives are asked, a general counsel are asked whether or not investment treaties factor into their decision to invest. And, who's going to say that I decided to invest or not on the basis of an investment treaty? If you ask governments about how these treaties affect foreign direct investment, at least the Western states who are trying to promote investor protection, they don't think that it's going to create more foreign direct investment. They think it will make foreign direct investment more efficient, right? It's not that companies will decide to invest on the basis of this necessarily. It's that it will have positive price effects for all concerned. And I haven't seen empirical evidence saying that they don't or that they do, right? So, I'm not saying the burden is on either side there. I'm just saying at this point, we're stuck with this regime for a while. And before we throw it out, we should really think about, whether or not this investment promotion goals are working and are worthwhile. But that said, we should throw out a lot of things about the regime right now, which has been the subject of this talk, because it is far from perfect.
Thank you very much. Here's a question. Suppose the investment treaties were to have a greater scope for counterclaim against investors. What approach do you think the ISDS bodies would likely take about separate corporate personality, particularly with regard to the foreign parent company being liable for local subsidiaries?
Yeah, I don't have high hopes, guys. So there's really only a few cases where these things have come up, where the liability shield has come. I took that question to be about limited liability specifically. So here's where it comes up. There's a case, Churchill Mining versus Indonesia. And it's a case where the investor brought suit on what turned out to be fraudulent permits, right? So the supposed investment was a bunch of permits to do mining. It turns out that they were fraudulently procured. It wasn't necessarily the investor who was suing itself that did the fraud. They apparently just failed to do due diligence, or at least that was all that could be proven. And the person who brought them the permits was the one who did the defrauding. Doesn't really matter. The point is that the investment was fraudulent, and so the tribunal awarded a costs award to Indonesia. So Churchill tries to annul the award. And at that stage, Indonesia says, well, you need to pay the costs first. And Churchill says, well, we're not going to do that. We can't do that because that would make us bankrupt. And then we wouldn't be able to litigate to our fullest rights and try to annul this award. And so Indonesia says, well, you should post security for costs at least. And they say, we can't do that because that would make us bankrupt. And Indonesia says, what are you talking about? Your owners, your wealthy shareholders are literally funding your litigation. And so it's your problem if they're keeping you purposefully undercapitalized such that you can only afford to litigate but not afford to post security for costs, because they could afford it. And the tribunal says, I don't want to hear about it. Limited liability, corporate formality. We don't look through the corporation to ask how rich their shareholders are. It's not up to us. All we see before us is this veiled corporation that has only enough assets to proceed with litigation. And of course, their right is access to justice. And we will not demand that they post money that would prevent them from litigating, because the corporate veil is so fundamental, so important. Now, where was all of that solicitousness when we talk about separate personality? I don't know, right? But here you see it. And that should give you an indication of where things are going to go in the counterclaims world, right? When it comes to making the company's parents liable, in the cases that we've seen it, few and far between as they are, admittedly, tribunals have suddenly been very sensitive to the corporate form, right? And again, I want to be really clear. I'm not making any kind of intentionality, motivational or causal arguments. I'm not saying tribunals are colluding with companies or doing anything, any kind of misfeasance or malfeasance. What I'm suggesting is that the pressures of the regime make tribunals, provoke tribunals to sort of grapple in these really problematic ways with the basics of the corporate form. I don't really know why, and I don't want to hypothesize why. We might all have our hunches about why, but it doesn't matter. Intent doesn't matter, right? It's not the issue here. The issue here is the effects and the incentives that are set by the regime, and those incentives are perverse. That's what matters here. So we don't need to get into the true motivations of the tribunals. What we need to understand is that the case law as it currently stands creates this really problematic set of incentives where claimants are coming out on top, but the real supposed beneficiaries of the regimes, investors as a class, and states themselves are tending to lose out. And the same thing is going to happen with counterclaims.
Thank you very much. Professor, we have, although we are, our time is running out, but we would like to convey 2 more questions to you.
I'm happy to, yeah.
That's great. Thank you very much. Your 6th question: with so much prospect of shareholder claims, why we do not witness that many municipalities of ISDS have claims by disseparate shareholder groups?
I'm sorry, I didn't quite, they cut out for a second. So with so many shareholder claims, what was it that you said?
With so much of prospect of shareholder claims, why we do not witness that many multiplicities of ISDS claims by disseparate shareholder groups?
I'm not sure if I fully understood that question. Is it written out here? Because somehow I can't hear something. Is this?
I would repeat the question again. But,
yeah.
With so much prospect of shareholder claims, why we do not witness that many multiplicities of ISDS claims by disparate shareholder groups?
I see. Multiplicities of claims. Got it. Yeah. Well, so there's 2 answers to that. So the first is that we do witness this, right? There's different kinds of shareholder arrangements and multiple claims arrangements. So sometimes we're talking about chains of parents and subsidiaries, right? We have seen cases like Ampal or like CME and Lauder, where the tribunals are, where the claimants are causing various entities in the chain to bring suit at the same time under different investment treaties to maximize their chances of winning. And again, I certainly don't blame companies for trying this, because they're trying to get recompense. They feel injured and they're trying to secure access to justice ex post. That is exactly what you expect of them. And that is why they think we have this treaty regime. So you can't impugn the motives of the companies and their counsel here, right? They're doing what they can to zealously advocate for their clients. That's fine. So then you see these cases where you have, or Orascom is another recent one, where the claims are being brought by, 4, 5, 6 different entities under different treaties, and tribunals have to grapple with that. What we haven't seen too much of is with like a publicly traded company where large shareholding groups bring separate suits, right? That's not something that we've seen so much, but you could imagine it. One of the reasons why it doesn't happen with very, very large publicly traded companies is because the individual shareholders just don't have enough skin in the game. So it's not enough of a loss. Citibank's shareholders, there might be an institutional investor who would feel that loss, but it's not really so obvious who's going to bring the claim or who's not. There's sort of real questions of collective action there, whereas the company will bring the claim if they can, because they have obviously suffered a massive loss. So that is one sort of explanation. But another explanation is that a lot of this stuff is really low salience. It's not that well known for investors and for shareholders. So repeat players in the field, the companies themselves, like mining companies, oil extraction companies, they know about the existence of this forum, and so they bring suit. But the shareholders of a big company are less likely to understand their rights. However, the regime becomes increasingly salient. Right now, you have, Elizabeth Warren is talking about the regime in the U.S. You have, famous people are talking about it in Europe, and there are protests about it. So the more well-known the regime becomes, the more these options, I suspect, will be exercised. But I'm not really that worried about publicly traded companies, shareholders, like tons and tons of suits from them. And I'm actually a lot less worried about the multiple claims problems and the double recovery problems than I am about the just general damage to the business environment, the general expansion of the costs of credit that arise out of this, meaning that all of the sort of benefits of the investment treaty regime aren't materializing, but the costs are getting supercharged. That to me is the real perversion here, rather than the sort of things that folks usually talk about, which is just multiple claims. That happens, but more with the parent subsidiary stuff and less the publicly traded.
Thank you very much, Professor. This is our last question, and it is by our chair of the Department of Law, Professor Rizwanul. While often the ISDS bodies deal with sketchy BITS, could they rely more on BCLT or other international law provisions to make things more coherent and sound policy-based?
Yeah, so it's interesting. I think the answer is yes and no, right? So if tribunals were more formalist in how they relied on international law, especially treaty interpretation and structural things like the Articles of State Responsibility, and the more they relied on the classical formulations of these things, likely they would do better, right? And that's, for example, in the corporate law context, the VCLT requires looking at the general international law in order to resolve the interpretation of a treaty, especially if that treaty is ambiguous. But even if it wasn't ambiguous, you're supposed to look at general international law. And general international law on corporate matters adopts domestic corporate law expectations. So that would be an improvement. I have my doubts about whether tribunals are well equipped to do the public international law dance all that well. There's a very problematic dynamic that seems to be happening where states tend to really focus on appointing public international law experts on the assumption that maybe they'll be more state friendly, or maybe at least they'll understand the treaty regime and how the treaty was a bargain between states, which was not just a free-for-all for investors. Meanwhile, investors appoint more commercially minded, more arbitration focused people. This is a little stereotyped, but it still happens. And the tribunal presidents seem to get swayed by one more than the other. The public international law experts, as brilliant as they are, write really great dissents, but there's a question of persuasion at the end of the day. And public international law, the formalities of the Vienna Convention, those things are like catnip to us, to public international lawyers, super convincing to us, but it's not necessarily that easy to translate. Believe me, I try all the time. It's not that easy to translate to commercial lawyers who don't know anything about the regime and maybe think it doesn't even exist, right? So the problem is an adjudicative one. Now, if we were to move to an investment court system where the judges had training in public international law, which is an expectation, at least on the EU's investment court proposal, that all the judges have experience with public international law, well, then that might be a very different situation. But one thing I will say, it's not always that well understood, but public international law has some pretty dramatically investor-friendly proponents in it, provisions in things that we sort of know and hold close and dear. For example, the Articles of State Responsibility recognize a pretty aggressive compensation regime towards our factory damages. And in fact, even the circumstances precluding wrongfulness are maybe notwithstanding compensation, right? So in the Articles of State Responsibility itself. So it's not entirely clear that the consensus on issues other than corporate law and public international law are exactly where we would want them to be for an investment treaty regime that adequately balances the drive to promote efficient investment against all of the risks and costs that are imposed on states. It's not clear to me that public international law is the best balance, but that is a question for a different day. On corporate law stuff, I do think the Vienna Convention would get us to where we need to be, mostly because investment treaties don't say anything about corporate law at all. And thank you for the question.
Thank you very, very much, Professor. Professor Arato, we have reached the end of the program. For those of you who were present here, I am very sorry that we could not actually entertain, we could not convey all of the questions to Professor Arato in order for him to entertain. However, thank you very much. And Professor, I would like to bring to the notice of everyone here that if you have missed any part of our class lecture, that would be available in our YouTube channel. That being said, Professor Arato, we'd like you once again in our program with some other topic, some related topic perhaps, and it was an absolute pleasure again to have you. Thank you very, very much.
Anytime. The pleasure was absolutely mine. Thank you so much for having me.
Thank you, Julian. Thank you all.
Bye-bye.